training was set up before anyone even had ever heard the word COVID-19. So most of my training is not related to COVID-19, but related to the areas that were requested for me to cover. However, as I said earlier, I've pulled an audible, and I will be throwing in some stuff at the end that is directly related to COVID-19. All right, Mia, take it away. All right, the first topic we have is writing an effective demand letter, and I believe all of my demand letters, I put together a packet of demand letters for different topics, and those have been set out to you. But some tips are, consider, it is good for some of our clients to consider writing a demand letter before starting a lawsuit, because sometimes the demand letter will clear up the issue. The important aspects is, a lot of time clients want to lay out every grievance they've ever had since the beginning of time to deal with this person. Remember in 5th grade when you stole my lunchbox and now you kicked my dog? And that doesn't apply when you want to fix a problem. So they need to keep it directed at that problem, be professional, be complete and detailed, and be reasonable. You don't get $12,000 when they ruined $100 worth of your lawn or whatever. And always end with, if I don't hear from you within 10 business days, or if I don't hear from you within 2 weeks. You can go to the next slide. Okay. What needs to be included in the letter is the details of what happened, specifically why you're holding the other person at fault, how you were injured, what this caused you, and what is needed to fix the problem. And include actual details, receipts, anything that's going to assist in that, and state the demand, and then the time frame. All right, I've given you all the examples. I wanted to go through a few with you. They will be hard to read on the screen, but I wanted to point some things out. You should have all of them, but I'm going to go through some of them now. And I'm going to start with the basic demand letter. This is just the most simple, in simple terms, what the issue is, why it's wrong, and why it should be fixed. And you can see this was for an insurance policy that he was quoted a price, and then he did his down payment, then they doubled the price, and he said, no, cancel me. And when they went to refund his money, they refunded it based off of the upped premium instead of the quoted premium. So we were trying to get him some additional money back. But you can see this is just where you would start with the demand letter. Then if you have to get a little more, put a little more bite into a letter, you can actually get to the point where you are citing statutes. You can see in this one, this was for a water treatment, a home water treatment, a reverse osmosis system. And this door-to-door person came and sold this to this elderly gentleman. He didn't need it. He had one. He had one that was under warranty, and he did not need this. And the salesman, high sales tactics, said, you do. And finally, this gentleman couldn't stand it any longer and like many do, he agreed. And so we threw in a little more of a bite here, saying that we believed this violated the FDUPTA law, and pointing out that there's more at risk when the person is over 60. And we got a lot more angry language in this. I will tell you that the outcome of this was that they ignored even the strong demand letter, and so we sued them and got the money back. We did get the money back, but so that's an example of a much stronger demand letter. Then we'll move on to some other areas where sometimes a demand letter actually works, and that's a cease and desist. A cease and desist always works, and if it doesn't, that's great too, because then we can sue them. And so with the cease and desist letter, it's that straightforward. You can cite the Fair Debt Collection Practices Act if you're dealing with a debt buyer such as Midland Funding or Portfolio Recovery or IC Systems or one of those myriad of debt collectors. You can also cite the Florida Consumer Collections Practices Act if you are dealing with a first party creditor. And all of these letters that I have given you can be adjusted so that the client can send themselves. Instead of saying I represent or we represent or so-and-so represents, the client can say, I hereby am requesting that you do this, that, or the other. Now, sometimes when a debt harassment or a cease and desist is ignored, you can technically do a demand under the statute. You lay out the statute number that you're relying on and how they have violated. Either you can do it for the Florida or the federal one, and you're requesting the $1,000 that the client is entitled to. For debt collectors, if they feel like they have violated, they'll send the $1,000 because they know if they don't, you're going to sue and get the $1,000 plus attorney's fees. Under the Florida one, a lot of companies aren't as familiar with the Florida statute, so a lot of times they will ignore this letter, but it is something that can be sent out. Another type of letter that is actually truly useful is the dispute to Equifax, Experian, or Twins Union. What this is useful for is sometimes it will 100% clear up the problem. If it is something that is obviously should be cleared up, a lot of times the letter will do it. But if the letter does not clear up, you can't move on to the next step of suing under the Fair Credit Reporting without this step. This particular letter should be sent via certified mail. Period. End of discussion. Clients will say, well, I already did it online. Great, do it again by certified mail. Do it again by certified mail is always the answer. Clients should and can send it themselves. It does not need to be sent by an attorney. And they should, this is a more generic one that I've included that just lists the accounts that are being disputed. But if there's a reason, that should also be stated. You should state, this is not mine, this is more than 7 years old, this is duplicate, the amount is not correct. If there's an actual reason why the client is disputing it, they should include that. The next topic we have is replevin actions. And replevin actions, of course, are to get property back. And this is personal property. This isn't going to work for a home or a car, but it is to recover personal property that is being detained. Where it comes up in our client situations is usually they were living with someone, a family member, a significant other, a roommate, and they had to leave for whatever reason. There was some problem, some issue, and they left something behind, and now the person who has it won't give it back, and they can move on with a replevin procedure. There are some different kinds of replevin procedures in the state of Florida. You have the post-judgment replevin case. This is like any other money damages complaint that someone files. You choose the venue, you choose which is the county where it is, you choose the jurisdiction that is based on the value of the property. You file the replevin complaint, which states, I mean, there are forms for this because it does need specific information. It is supposed to state the item, where it's at, why that person has it, and it has to include a statement that they won't return it. And then you file it, and then it proceeds like a case. So if you're in small claims, if it's less than $8,000, then you're in small claims. There will be a pretrial, and they will proceed with the pretrial. And then move on to a judgment. If it's in county or circuit, they can turn around and set it for a final hearing and get that judgment. When the judge signs a judgment, that's really directing the clerk of court to issue a writ of replevin. So the client then needs to go after they have their judgment and get a writ of replevin, and then they take that to the sheriff, and it's executed by the sheriff to go physically to that address and get the property back. Most replevin complaints also contain an in the alternative for the money. And if they show up and the person says, you know, I got rid of that, I don't have that, then it turns into a money judgment, and they take their normal steps to collect that. Florida also has two types of replevin where they're called pre-judgment replevin. And under a pre-judgment replevin, you have two types, and one they call a no notice, and one they call it's handled a little differently. The no notice one is going to be much harder for our particular clients to do because they require a bond to be posted for the amount, and usually double the amount, but up to double the amount of the item. So it's harder to do it, but the value of it is the other side doesn't get notice that you're doing this, and a lot of times that prevents the item from being destroyed, hidden, lost, given away, sold, whatever. But it has to be, it's only available when the defendant, or you allege that the defendant who's holding the property is going to engage in conduct that may lead to the destruction, concealment, waste, removal, transfer. You have to allege that as part of a no notice. And so you still do a complaint for replevin, but it has to include this language in it that you have that fear, and you also file it with an affidavit of emergency. At the same time, you request an ex parte emergency hearing, the judge issues a judgment, and the writ of replevin is issued. This is more like a garnishment when our clients don't know and then their bank account is frozen. That's how this happens, because afterwards the other side can request a hearing to dissolve the writ of replevin, claiming this wasn't their property, this is my property, and they can undo it after the fact. So the other, the last kind is a show cause. To me, there's not a lot of, they call it a no notice, but to me, a show cause gives notice. You don't have a bond, so that's good. You file a complaint and a request for an order to show cause are filed at the same time, and the show cause hearing is set. But the other side gets notice of the show cause hearing. They're going to know what's going on at that point. So to me, there's not a lot of need. Either you can afford the bond and you do the no notice one, or you can't and you do the other kind. But this is kind of halfway in between. At the order to show cause hearing, if the judge finds that there is a cause to issue the writ, they'll enter a judgment, and again, you can go to the clerk, you get the writ of replevin, and the sheriff goes and serves it. So those are the types of replevin. All right, our next topic is declaratory judgments. And a declaratory judgment is to determine what your rights or obligations are, usually under a contract. There doesn't have to be a breach, so that it's a good tool to use, because there doesn't have to be a breach, but there can be a breach. And you're not seeking any kind of money or an injunction. You are seeking the judge to say, yes, these are your rights under this, under a declaratory judgment. There's, first of all, you have to have a bona fide, actual, present, practical need. You cannot be seeking a second opinion. You cannot be seeking, you have to have a dispute. A lot of times what you have, one example is you get, okay, I'll use a practical example. Here in Spring Hill, there was a chiropractor. His last name was Hess, and he did a big green Hess sign out front. And Hess, the company, found out and sent him a cease and desist for using their information or their logo. And if he thought he wasn't using their logo, or he had a right to, he could have done a declaratory action to determine his rights. I think he just changed his sign. But so you have to have an actual dispute. You have to be seeking information on your immunity, power, or privilege or right under some agreement, contract, request. You're looking for that. And it, like, number 6 is important. You're not seeking a legal advice or the answer to a question. It has to be an actual, this could turn into litigation, so let's get a judge to do a declaratory action. All right. Some types of declaratory actions, they're used a lot in insurance claims. Back 100 years ago, when I did PIP cases, which is personal injury protection under car insurance, it's that $10,000 of coverage that you have, and we would file against insurance companies who didn't pay out those benefits to doctors or to the person directly. You would do a DEC action as part of your claim to say that you want the judge to declare that this is the actual insurance policy that applies to this case. There's ways to use it. Any type of contract dispute is a good place to use a declaratory action, but where I most see them in our clients is obtaining a car title. So that's what I'm actually going to go over because it comes up the most. Is you have a client who has purchased a car and they've paid for it, but they can't get the title. The other person won't give it to them. The shady car dealership doesn't have it. Whatever, they don't get the title. Now, technically, if it's a car dealership, you can sue, but you could do a deck action. So the steps for attaining a car action using a declaratory judgment is to do the complaint for declaratory judgment. This is a form. You fill out the form. You need a summons. You need an affidavit of vehicle title application. And then you have to go to the DMV and get the motor vehicle vessel and mobile home records request. That's a form that the DMV has that you can fill out. You're making the request to see basically the chain of title. You have to fill out a vehicle identification number and odometer verification. And then you take all of this documentation at one time and you file it. When you file it, then you have to have it served. Now, sometimes if you bought this from a shady individual, you can't find them. They have fled. The one we helped a client on, we believed the guy had fled. This type of action is one of the type of actions that allows for publication. So you do attempt personal service first. If you can't obtain personal service, you take the steps necessary to do it by publication, which is your due diligence, and you file all that, and then you do the notice of action, and then you publish in a paper. Whether you get personal service or service by publication, they get 20 days to respond. If they do not respond, you can seek your default judgment. If they do respond, you can set it for a final hearing. The person is going to want proof, though, some kind of proof that they paid for this. Some kind of transaction, a receipt, a canceled check, a bank statement. They're going to want some kind of proof that they have paid, or if it's a car dealership, that they are paying or have made payments and continue to make payments. They're going to want to have all of that available as well. And at the final hearing, if they have that showing that they've paid for it, the judge will sign an order declaring that they are the rightful title owner. They take that to the DMV, and the DMV will switch title into their name. All right, HOA foreclosures. Everyone always wants advice about HOA foreclosures. The problem with HOA foreclosures is there's very next to zero or minus zero oversight of HOA. So there's not a lot of places to get HOA assistance, but I will tell you what there is. It's important when discussing HOA foreclosures with a client, the two ways they do sometimes screw up is through their notices, okay? The first thing they're going to do is it has to be $1,000, and then they can file a lien, the HOA, but they have to give 45 days notice that they are going to file a lien. Pay this money or we will file a lien. Hopefully we get lucky and the client calls us the day they get that letter, because then there are some things they can do. At that point, they have 45 days and they can check into why this is owed, and they can set up their payment plan and be done with it because at that point they do have to wait till it's $1,000. So you'll see most of these liens are $1,000, $1,100, something that our clients might have the chance of paying off. The problem is they tend to ignore that 45-day letter and they don't contest the lien. Well, I did put up the information that they can formally contest the lien. If they formally contest the lien by filing or serving an actual notice of contesting a lien, the association only has 90 days after being served with the notice to file an action. So that's why we hope that they come to us when they get that letter and they can either contest it or figure out, yeah, I do owe it, I just couldn't afford it, can I set up a payment plan, that sort of thing. Because what usually happens is all of that is ignored and you go on to the next step, which is they're going to file for foreclosure. Now they also have to give, in the next step, they also have to give notice for that as well. But what people get upset about is they're like, I only owed X number of dollars and this has all this other stuff. Well, it can have the assessments, but it can also have late charges, attorney's fees and costs, and interest. And it is dang high interest at 18% a year. And the attorney's fees are usually can be outrageous. So, you know, they owe this small amount. And I'll give you one example. I had a client who found out at the end of her case, foreclosure case, that this went back to $50. $50. And she had never paid it. There had been all of this disagreement. It had built up and built up until it was $1,100. They did the lien. She never did anything to take care of it. They filed for foreclosure. She contacted us. I spoke to her and I told her, settle. If you can't settle, sell your house, because she had $70-some thousand of equity in her home. I said, settle or sell your house. And she said, no, I'm fighting this till the end. She fought it till the end. At the end, she was going to lose her home. So she decided to sell her home. She sold her home so she could get some of the equity herself. And she ended up paying the HOA $12,000. $12,000. It can and will and does include all of that. Some HOAs will work with you, most will not. You are going to be paying it. They do have to give the second 45-day notice to initiate a foreclosure. If the client didn't call us when they got the first letter, hopefully they call us when we got the second letter, because there's still things that can be done to help them. Usually that's not true. Usually the foreclosure is filed, and foreclosures in Florida take the same steps as a real property foreclosure. You know, they file, they do the lis pendens, they take all of the steps to get a foreclosure, and they have a sale. And a lot of clients are not going to understand that if they're up to date on their mortgage, either up to date or maybe don't even owe a mortgage, but either way, their mortgage is up to date, they think the HOA can't take the home, and the HOA can take the home, will take the home, and do every day in Florida take people's home over a $50 freaking HOA fee. They sell the homes subject to the first mortgage. So the first mortgage doesn't get wiped out, but they do sell the homes, and they will take their home, and they will absolutely kick them out. There is one thing that can help, but it's only for clients who can afford it, which is usually not our clients. But I wanted you to be aware of it so that for people who can, they can make a qualifying offer. After the foreclosure action has been filed, But before it's ordered to sale, they can make a qualifying offer. What it's going to do is it's going to cut the bleeding, because it's not going to, they can't add in a bunch of more attorney's fees, and there's a stay for 60 days. Well, up to 60 days, but usually it's granted for the 60 days stay. And if they can make that payment within those 60 days for everything that's owed up to that point, then the case is over and everything's released, and it doesn't go on and continue to gain and gain and gain. Now, the home can't also be in a mortgage foreclosure, and the homeowner can't be in bankruptcy, and it has to be at least 30 days before it says trial date, the final hearing, because there are no jury trials for this, but the trial date has to be at least 30 days away. So they can make this, they can only make one of them, and it will help them get this all taken care of, and cut some of the attorney's fees out. But most people, unless they do it at the very beginning and unless they have the money, can't do it, but it is an option. All right, defending an HOA foreclosure. Honestly, you can check the liens, because they have to have very specific language. So you can check the liens and make sure they are valid, and that they followed the proper procedure, and are there your normal contract defenses apply, and your normal 5-year statute of limitations apply. So you have your normal defenses, but for most of our client, there's usually not a lot of defenses. You will want to review the bylaws and all of their rules that they make for themselves, that the HOA has, that they have to follow, because sometimes they actually put in additional steps that they have to take or they have to follow. And if they haven't followed their own laws, that can be a defense that gets it dismissed. So was the notice prior to the lien correct? Was the notice prior to foreclosure correct? Did they follow all their own bylaws, covenants? Did they follow all of those steps? And is everything brought properly? And is it within the 5 years? Otherwise, that's it. They're going to win, and people need to understand how likely in the state of Florida they are to lose their homes over an HOA foreclosure. Now, HOA foreclosure and bankruptcy. The law changed in 2015. You cannot strip an HOA lien in a Chapter 7 bankruptcy. The Florida Supreme Court came out with a decision in June of 2015, which stops the stripping of HOA liens in bankruptcy. Now, it can buy people time. Some people are like, okay, I know I'm going to lose my home, but I need more time. Okay, file a Chapter 7 bankruptcy, buy yourself 6 months. A Chapter 13 does still allow for dealing with it in 2 ways. One is, obviously, they have the 5 years. So when the HOA learns, okay, they're going to have 5 years to pay this back, they're going to be more willing to work with them, and they can usually get it paid back in 5 years. Also, they can be stripped and brought down to their market value. So if there's all this ridiculous charges on it, it's stripped down to its market value. You have to still pay the market value off during the 5 years, but the rest of it's treated as unsecured debt and can be discharged. So if someone truly wants to save their home and they can afford a Chapter 13, they can deal with it. They have to continue making the regular monthly payments of the HOA. If they have a monthly fee, a quarterly fee, a yearly fee, whatever kind of fee they have with their HOA, they do have to continue, in addition to the Chapter 13 payment, make that payment. But it is an option. Every once in a while, we do have clients who can and have used that to deal with an HOA foreclosure. All right. Student loan collections. I wanted to include this because there's a lot of questions that come up. And what is important to understand is federal loans, student loans, have no statute of limitations. So when someone calls you and says, this was from 20 years ago, okay, but there's no statute of limitations on federal loans. And then you have someone who calls and says, my income, my paycheck is being deducted from my student loans, but they didn't sue me. They don't have to sue you. They can use their administrative wage garnishment. It's no lawsuit required, but it is 15% of disposable income. It is not the 25% a creditor can take if they get a judgment. It is 15%. Notice is supposed to be sent 30 days before the garnishment begins, and they can request a hearing, but their best bet is to avoid it is to enter into an acceptable repayment plan. We have a lot of clients that they have low enough income that their income-based repayment plan is going to be lower than the garnishment. That's what they don't understand. They assume that these student loan payments are going to be hundreds of dollars, and I don't have hundreds of dollars. But an income-based repayment plan can be very low and affordable even for some of our clients. And a lot of times the problem is it requires it being taken out of default, because usually they're obviously in default and they've got to get these loans out of default and enter into a repayment plan. But otherwise, if they don't take those steps, that administrative wage garnishment can last until the end of time, and continue into their Social Security. Because the only Social Security that is fully exempt is SSI. If someone's getting Social Security retirement benefits or Social Security disability income, they can take 15%. Now, the one protection is the first $750 is exempt, but if someone gets $1,000, they're going to get part of that. That's over the $750. They're going to get 15% of that. Now, the Social Security can also request a hearing to demonstrate hardship, and they sometimes get it issued more often than a worker. If you have the ability to work, less likely that you're going to get the hardship. But with Social Security, they can and will get those. So that is an option for our Social Security clients, is to actually get the hardship. They can also intercept and do all tax returns. So that's another thing that people need to understand. All of those things happen with federal loans without being sued. None of those things require a lawsuit. So curing a default, they need to contact their servicer and request to cure the default. They are set up based off of a reasonable and affordable. They do take into account your expenses and your income and your dependents. It is a generic formula that is used. It's not published somewhere. They just do it over the phone. You literally talk to them on the phone and they ask you all these questions. It's not formalized and you don't usually have to prove it. And you're set up on a payment plan. You have to make 9 absolutely on-time payments within 10 months. They'll tell you 9 payments in a row, but it's really out of 10 months. So if you accidentally miss one, as long as you don't miss any other ones and you get 9 in 10 months, then you're going to qualify for the default. collections do not cease during this time, so that's not going to stop letters and stuff coming in. You can only cure this way once. So if they've already cured default, then they're out of luck. Now, once they reach that cure, the good news is they get set up on an income-based repayment plan. That they do have to prove. The first time, it's informal. It's over the phone, and they take you at your word. When you do the income-based repayment plan, once you get out of default, you're going to have to prove your income and prove your, they're going to ask for documentation to prove some of this stuff. But the default notation on your credit report is removed. So you do a new agreement, and once you hit the other good news is once you hit the 5th payment, the income is removed. So if they've turned you over to a debt collector, you have to arrange this through a debt collector. A lot of people don't like dealing with the debt collector and they want to deal with the servicer directly, but they're not going to do that. If it's turned over to the debt collector, you work with the debt collector. But once they cure that default, even if they have to struggle to do that and they get on that income-based repayment plan, some of those are very, very small payments, all the way down to zero. The payment can actually be $0. That's your payment. Not every client's going to hit a $0 payment, but there's been a lot of small ones, $10, something like that, 20, 30. They can be fairly small payments, and most of our clients are going to have low enough income that they're going to meet that low to no payment, but they got to get it out of default to do that. Private loans. Private loans are like any other contract. They do have a statute of limitations. They can't do administrative wage garnishment. They can't intercept your taxes. They can't garnish Social Security. So you do have some luck with private loans. You can attack the chain of title. You can attack their accounting. They do use the actual debt collectors, so you might end up with collection violations, and you can sue the debt collectors for that and the private loans. Now, they do maintain the protections that federal loans have, which is they are protected from bankruptcy discharge. Initially, it was just federal loans, and then several years later, the private lender said, we can't continue to do this if you're going to let everyone get out of school and bank, because that's what people would do. They would go to school, they would still be young, they would have all this school debt, they would say, I don't care about my credit for the next 10 years. They would file bankruptcy and they would wipe it all out and rebuild their credit and have no student loan debt. Then the federal government came in and said, nope, we're changing that, but they only protected themselves. Then they extended that protection. So you can't typically discharge these in bankruptcy. I know there's a hardship discharge available in bankruptcy, but that is like seeing a Yeti. 1 out of 1,000,000 people have seen that, and it's not very likely. Less than 1% of the people who even go for it get it. It's low, so it is possible, and it does happen, but they're going to have to hire an attorney who has done it before and knows how to do it, because it's not very normal. But with the private loans, you do have some of these other protections that you would normally have. And actually, we do some pro se assistance with private loan lawsuits, and have gotten a few of them kicked because they have the same problem that, say, debt buyers have. This debt in private loans is transferred ridiculous amounts of times and ends up in these weird trusts, and they never have the paperwork, and their accountings are never correct. So once they do file a lawsuit, there are some defenses, and it's the chain of title and the accounting. And we've seen some pro se clients get some dismissals on private loan collection lawsuits. and we will assist with that. I do have all of the paperwork to help people not only do a motion to dismiss, but to do the answer and affirmative defenses and the discovery that they need to do to really fight those once they are in court with them. All right, student loans and COVID-19. I wanted to give some information about this. Okay, we've heard that there is a suspension of payments and interest through September 30th. This only applies to federal loans owned by the Department of Education. Some people old like me who went to school 20 years ago have federal family education loan program loans. Those are federal loans, but they were initiated by a bank and they are not owned by the Department of Education, and you do not get the suspension of payments and interest. The good news is those went out of existence in 2010. Anyone whose loans are since 2010 don't even have to worry. If you've got a federal loan, it is a Department of Education loan. Payments are suspended automatically, no action needed. You do not have to call and request it. You don't have to take any steps. Also, if they are suspended and you are working towards a public service loan forgiveness, the Department of Education still counts all of those months of suspended payments towards your loan forgiveness. So it's actually a pretty good deal. Now, there are servicers of these other types of loans and private loans that are offering some assistance under what they're calling a National Disaster Relief Plan. Okay, they are not automatic. So if you have the FFELP loans or a private loan or a client calls about that, they should call their servicer and request. It's called an administrative forbearance. Okay, it's called an administrative forbearance or a national disaster forbearance, and it's a case-by-case basis. It is not mandated, required. It depends. And you call, you request it, and they give it. You don't have to prove anything. That's the good news, is the ones that are offering it, if you call and request it. Now, I will say this, the difference is it's for 3 months. Most of the ones that I've checked into are 3 months and not till September 30th. Also, interest does not stop. Interest will continue, the ones I've checked into. You might find a servicer that's different because it is a case-by-case basis. But the ones I've checked so far, interest will continue, but it will not be capitalized. Usually if you get a forbearance or a deferment from, you have the interest accruing on like a private loan, and then at the end of it, they capitalize it and add it right back into your overall loan. But the good news is they have taken the capitalization of that out, and so even though you are getting some interest added in, if a client or someone decides to do this, at least it's not being capitalized, and the 3 months can help missing those payments for some people. So a lot of people aren't going to know what kind of loans they have. They've got to go on and they've got to see. It's going to say what kind of loan you have, whether it's, see who owns it. If you have a federal loan and it says it's owned by Navient, you do not have a Department of Education loan. It will be a direct loan and it will say that it's owned by the Department of Education. So the clients can find this out fairly quickly and easily online. Go to the servicer. If they can't find it online, call and ask. I mean, this is not hidden information. So they will have to do that. All right, that's it. So my Audible, my information that I wanted to give you all, and then I will open up for questions, is so far there's a ton of information out there. There's a lot of websites that are giving information, but one for consumer law, since I'm talking about consumer law today, one of the best I have seen is the COVID-19 Consumer Resource Center. The website is www.consumer.law. No .com, no .org, no not, it's .law. And this is a nationwide, so it's not Florida specific, so you got to look and see if it applies to Florida, but it's been put together and it gives information about mortgages, protecting your credit cards, rent, prioritizing debt collection, student loans, auto loans, scams, and fraud. It has everything that any consumer issue that might be raised is here, at least an overview. And this encompasses some of the information put out there by NACA, and some of these attorneys have put this information together, some of the big law firms that do this, and the student loan lawyer, they have went out and researched this, and they have links and when you go in and look at each individual item, they have links to each state. So you can go in on this website and look at Florida's information there. And then if you have specific questions, you can always contact me directly and I will try to answer that question. Now I wanted to open up for any questions that people have.
Angela, I have a question in reference to the HOA foreclosures. And in your example, you talked about, owing the HOA like $12,000 and how, of course, that doesn't strip, the primary lien holder, the mortgage holder, and what they owe for their primary mortgage. So after there is a final judgment, or maybe somewhere in that process, should the client be filing some sort of like something for like the surplus funds that, may be or may not be a part of the sale, depending upon, how much they owed for the remainder of their primary mortgage added to whatever they have to pay to the HOA?
If they have some big HOA and they decide to sell, they will get the surplus because they're selling it themselves. They'll get a payoff statement from the HOA and from their mortgage, and at the closing, they'll get the surplus. Now, there won't hardly ever, if the HOA does the auction themselves rather than the homeowner. That's why I always say to the homeowner, when we have a call for an HOA, the first thing we say is, after we get the basic information and tell them their options, is, do you have equity in your home? Because if there's equity in the home, the homeowner should sell it themselves, because if the HOA sells it, there's not going to be a surplus because they're going to sell it for what they're owed. They don't sell it for the full amount. An HOA, let's say the HOA, like the case I talked about, had the HOA sold it, they would have sold it for $12,000. That's what they would have sold the house for, because the first mortgage stays with the property when they sell it. The new owner has to deal with that first mortgage. They either have to then pay the first mortgage or live in it until the first mortgage comes and forecloses, but the first mortgage is still there. It does not go away. So that the HOA auction is for what they're owed, and that's it. They don't ask for more than what they're owed, so there's not going to be a surplus.
Okay. Is there a time limit as to how long they have to try and sell it? Like at what point in the process?
Well, there's an auction, just like a mortgage foreclosure. There's an auction, and it sells that day. And if it doesn't sell that day, what the HOA does is they buy it themselves. So HOAs will buy the home, and what the HOA does to get their money back is, kick you out, kick the client out, and rent it. A lot of HOAs will rent out these homes they take, and then they take that rent in to cover what expenses they've had. So it is going to sell that day, either to another person who buys it, because some people will go around and buy up these HOA foreclosure because they know the mortgage is going to take a year to foreclose or whatever, and they rent it out themselves for a year. So there are people who buy them. If no one buys it, just like a bank foreclosure, when no one buys it at auction and it gets transferred into the bank's name, the home gets transferred into the HOA's name, and then they'll rent it out or do whatever they want with it. And then, they can once that the surplus is from that first transfer. So if it's transferred to the HOA, there is no surplus. If there is equity in the home and the homeowner didn't take advantage of it, the HOA can turn around and sell it for full value, pay off the mortgage, and take the equity themselves. That is why clients need to figure out, is there equity? Can I work out a payment plan? Am I going to do a Chapter 13? And be serious about it, because otherwise they end up like my client, who I told to work out a settlement at $1,100, and she refused and ended up having to pay out of the proceeds when she sold her home $12,000.
So for the owner to sell it, like, is there a certain time or point in the process, like after judgment, they still have a certain amount of days
they can
before
still
auction?
After a judgment, the sale date is set. Okay, and it's usually 45 days after the judgment, because there has to be a publication of 30 days. And so it's usually 45 days. Now, some judges, if the client is being considerate and has an actual reason, will set it out further than 45 days. I've seen 60 as fairly common. I've occasionally seen 90. And once or twice I've seen 120. I've never seen past 120. And the 120, the woman was severely disabled. And so she was given this 120. So they're going to know usually at the final judgment hearing, usually that day or shortly thereafter, the sale date is set. And so they do have a little bit of time. The thing is, they've got to do a closing. So if you wait until final judgment, you might not have enough time. Now, some judges, and this is a case-by-case basis and not a guarantee. Okay, you wait till the final judgment. You hurry up and put it up for sale, and you get an offer, but the closing is going to close 2 days after the sale date. You can file a motion to continue the sale date and attach paperwork showing there's going to be a closing 2 days later. Most judges will give that to you, because why not? It's 2 days. But you have to be, I usually tell people, put it on the market. You can turn down offers and you can remove it from the market, but you can't hurry up and slap it up on the market the last day and hope to get it sold in time. So they'll know the time frame once that final judgment hits. Now, not every judge sets the sale date, that final judgment, and it's up to the attorney for the HOA to set it, but they're going to know fairly quickly. And I always just tell people, guess 45 days, because that's most standard.
My second question, Angela, relates to like the qualifying offer. I know most of our clients really don't have leverage or kind of legs to stand on, but is there anything that they really should be going into the process, like looking at, if they are able to negotiate one with the HOA?
There are HOAs that will absolutely negotiate. One little bit of leverage is if there was some debt collection that happened before, they can try to use that. But that area of law, when it comes to HOAs and debt collection, is very gray. It is not black and white. And that is because there's some old case law in Florida that is completely ridiculous that says HOA fees are not consumer debts. Therefore, the debt harassment statutes do not apply. I I don't understand how an HOA debt is not a consumer debt, because you have to pay it to live in your home. But there is a change in the law, and it is changing. I just don't like to give people, oh, you can use the debt harassment lawsuit if they harassed you to try to keep some of this from coming back on you, and you can use that as leverage. And then, they bring out that case law that says it's not a consumer debt. So I've seen, there's no solid gold leverage out there. It is a case-by-case basis, and some of these HOAs are ridiculous Gestapos who are going to every penny, and there are some who are like, we just wanted you to pay. Okay, let's do a payment plan. Yeah, we'll waive the interest. Yeah, we'll waive the collection fees, and they will work with you. It depends on the HOA, and there's no good leverage to get them there. It's just, is the HOA reasonable or not?
Angela, if the HOA sells the property, is there to someone else, is there a redemption period for the homeowner to get the property back, or no, it's over?
It's over. It's over. Anything they want to do has to happen before the sale date, including bankruptcy. If they file bankruptcy the day after, it's not going to be undone. They've got to file that bankruptcy or do anything they're going to do the day before the sale, before that sale happens.
And if the person, the example you gave with the $12,000, if the person who purchased the property and say this is a $300,000 property, that person doesn't have to necessarily qualify for this mortgage. It doesn't matter about that. They can just pay that $12,000 and it's pretty much their home until the bank comes in and really.
Correct.
Okay.
Correct. It's subject to the first mortgage, so the first mortgage is still hanging out there. They don't have to qualify for it. They have to make arrangements to pay it if they want to stay in the home. But I've heard of people who, will just either rent it out or stay in it and then fight the foreclosure. And if they fight it, the foreclosure long enough, they could have the house for a couple of years. Back in 2008, when the foreclosure market, when the housing market collapsed and there was literally thousands and thousands of foreclosures, the difference between now and then is people were staying in their house after foreclosure proceedings had started for 5 years, 6 years. So that's the difference between now and then, which might happen again depending on what happens with all of this COVID-19. If a lot of people are taking these without understanding the forbearance and they're taking it and then they have 3 months of payments come due, when hurricanes go through, we have the same problem on a smaller scale. So I expect it to happen because I've had to help a couple of clients with foreclosures after Irma. When they took the forbearance, they got 3 months, and then the 3 months came due, and they didn't have 3 months worth of payments, and they went into foreclosure, and then they couldn't save the house through modification. I expect that to happen at the end of COVID-19 too. So you can stay in the house so there are people who will do that. Usually it's to rent it out rather than to stay in it themselves, but it's also can be, not all of them get up to $12,000. It's cheaper than rent to go if you have the money up front, and it's closer to like $5,000, and you pay the $5,000 and you buy the house and you move in and you fight the foreclosure and you're there for a year and a half, and you've paid $5,000 for a year and a half of living. Some people do it. To me, like, all that moving would get frustrating, but some people will do it.
I think my confusion is, if that mortgage was in John and Mary, Jackson's name, and this other person comes in and buy this property, how do they speak with the mortgage company and not their mortgage?
It's not their mortgage. So it's not their mortgage. John and Mary, the first homeowners, are still going to be facing a foreclosure on a property because it's, but they are going to be named as the occupant of the home in the foreclosure. So they are going to be able to fight the foreclosure. They can't necessarily get the mortgage transferred into their name.
Correct.
or modify the mortgage or do anything with it. But when it comes time for the foreclosure, they will be named because they occupy the home as an occupant, and they can fight it and have the right to fight it because they occupy the home.
Okay, thank you.
Other questions?
Angela, in your experience, when dealing with the HOA foreclosures, being that the primary, the mortgage, the lender is kind of like an indispensable party, do they ever intervene? Like,
No, they are not an indispensable party. They do not intervene, and they are not given notice. They cannot be included as a party because they are not being. When you do any type of foreclosure, you only give notice to people whose liens can be erased. So when you have a first party mortgage that does a foreclosure, they're going to notice everyone. They're going to notice the second mortgage and the HOA and the home builder, the AC repair guy who put a lien on. They're going to notice everyone because they can wipe all that crap out. The HOA does not have the right to wipe out the first mortgage. So they are not an indispensable party. They will not be noticed, and they cannot be included. And if they are included, they'll just get dismissed from it. They'll say, we're not a party to this. Peace out. And they will be let out of it. So they are not an indispensable party, and they will not step in and do anything.
Angela, you mentioned on the student loan portion regarding our clients can request a hearing and there's forms for that. Is that on a certain website, or do you have those forms, or you mentioned some forms they can file to get a hearing?
Well, when they're going to do administrative wage garnishment from someone's paycheck and they get notice of that 30 days before it begins, they get the forms with them, like a garnishment. They get the forms with them. But the Department of Education also has a lot of those forms on their website.
Thank you.
Mm-hmm.
Angela, on the student loan garnishments, is that notice sent to the individual as well as their employer? Because I know that sometimes you hear people telling you that they did not know about the garnishment until their employer told them that their wages were being garnished because of their student loans. So are there simultaneous notices being sent out to both?
No, the notice is going out to the lender. I mean, to the client. They're not, maybe not getting the notice, or they're ignoring the notice or whatever, and then they find out from their employer. But that's usually right when it's going to be happening, like the money's going to start coming out, and that's when the employer knows. And they can still go back and request the hearing just because they didn't get their notice or ignored their notice or threw it in the trash, or it went to a different address or whatever. They can still go on and get the forms and do that. And I can look up the forms and provide those.
Thank you.
Okay.
Angela, I just one last question. So,
Sure.
in response to that, does that mean that what I liken that to is like how Social Security sometimes they say good cause. If you have good cause, we'll extend the amount of time that you have to do, why you didn't respond. So, is that the equivalent with like the U.S. Department of Treasury, like their offset unit that they have?
As far as the hearing,
Mm-hmm.
it's for hardship, or for another reason. I mean, there can be other reasons, like this isn't my debt. Where is this coming from? Like you can raise any reason, including hardship, but there can be other reasons, like I've been paying. Are you crazy? There can be other reasons, and those can all be raised. I mean, I have a lot of information about that for anyone who wants more information about that. Email me or let me know, and I'll provide you with that. I have a lot of information on that. I could do a whole training on student loan collections.
And one I promise last question with you know, parents who have co-signed on loans, and you know, the student may have just, you know, completely ignored it, may not be employed, but now it's kind of coming back on the parents and they're receiving notices. Is there something like special parameters for?
They get the same collection. You know, anything that I've said that applies to the borrower applies to the parent who co-signed. The same exact parameters apply.
Okay. Thanks, Angela.
Yep. Yep. All right, I do recommend everyone go to the COVID-19 Consumer Resource Center at that www.consumer.law and take a look at it. There is a ton of good, they've put together a lot of information in one space. So when you have free time, take a look at it. It's a great resource on consumer issues. It is just consumer issues, but it is a great resource for that. So thank you all.
Thank you very much, Angela. This was such an awesome and very, very helpful presentation. And I know it's going to help us in like moving forward, especially, you know, with the times we're living in right now. So thank you. We really appreciate you.